Chairman of the Code Compliance Board, and I call this meeting to order. The NSB Code Compliance Board of August 21st, 2025. The procedures of this hearing are to provide due process to every respondent and the city in accordance with Florida State Statute 162.073, which states, formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceeding. Hearsay is admissible, but only to support other competent, substantial evidence. Other evidence must be presented. Are there any questions? Any decision made today can be appealed by sending notice of appeal to the Circuit Court within 30 days of the execution of the orders per Florida State Statute 162-11. Can we have a roll call, please?
Yes. Dan Coffer?
Here.
Clifford Warren?
Here.
Albert Szymanski?
Here.
Aaron Dennis?
Here.
Kathleen Brown? Absent. Ruth Harris?
Here.
Keith McWilliams?
Here.
Does any member have any disclosure of any ex parte communications? For the record, there are none. And had each board member had a chance to look over the minutes from the last meeting on July 17th?
Yes.
And do I have a motion?
I make a motion to accept the minutes.
Second.
Dan Coffer?
Aye.
Clifford Warren?
Aye.
Albert Szymanski?
Aye.
Aaron Dennis?
Aye.
Ruth Harris?
Yes.
Keith McWilliams?
Aye.
Motion passes.
And can we have the swearing in of any city staff, respondents, and any witnesses that may testify before us today?
Please stand and raise your right hand. In the matter to which you are about to give testimony, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? The witnesses have been sworn in.
First case?
First case is 102 East Circle Drive. Officer John Parks presenting.
Afternoon. The address involved is 102 East Circle Drive, case number CCB-0140-2025. Excuse me. This property is zoned R4 multifamily residential. Violation cited is LDR 504.01 subsection N, general zoning regulations, short-term rental. On July 17th, 2025, the board found Eric M. and Erica Lee Wendorf and/or entity in violation of LDR 504.01N and gave until July the 28th, 2025 to bring the property into full compliance. If the board found that the violations were not corrected by this date, a fine of $150 per day shall be imposed for each day the violation exists. The board order was mailed certified mail to the property owner and was returned marked return to sender. The board order was posted on the property on July the 18th, 2025. On August the 6th, 2025, a check of the listing showed the property as still being available for short-term rental 3 days. I additionally just made an inquiry today, just a few hours ago, and here's a copy. Showing that a 3-day rental is still available for the property. It's staff's recommendation the board impose a fine of $150 per day commencing on July 28, 2025 and continue until the property is brought into full compliance, fine not to exceed the maximum amount of $15,000.
And for the record, there is no one here to speak upon this case. Are there any questions from the board members?
Yeah, have you been in touch, or have they been in touch with you?
There's been no communication between the property owner and I since the last board order.
Thank you.
If I'm remembering correctly, didn't he say that as of August 1st or some other date, he would be stopping it from being available? Because I'm seeing this as May of 2026. So is that, am I remembering that correctly?
That was just a random date that I utilized to see the future out. I do not recall any statement of that, but I
Okay.
don't recall. We'd have to refer to the minutes of the actual
It does
testimony.
say
of
it
the
in one of
conversation.
these emails.
That's what I was remembering, because I thought it was August 1st or some date shortly after the deadline.
I've had
where he was-
emails where he has advised that he would comply, and I've also had
There it is.
emails where he contests also his rights as a
Right.
property owner to do what he wants with.
So he said he would stop renting it out August the 1st. So I guess, my question was, I guess he was not being truthful when he said that.
You'd have to draw your own conclusion. I'm not going to state whether someone's truthful or not.
Okay.
But the email states, he says in the email that it's unconstitutional for us to.
There's an argument made by him as well.
Yeah.
So again, I'm not going to,
Yeah.
I can't advocate for him or on his behalf.
He says, I pay $5,000 a month, property tax, and you don't need to tell me what to do with my property. And August 1st, it does say it, but that does say
Yeah, May, so.
2026.
Okay, that was just what I was wondering.
It's fine. Again, the documents speak for themselves.
Yeah.
Okay, thank you.
You could pass that to
I
the
move
press.
that we accept the recommendation.
I second.
Who was the first? I'm sorry. Clifford? Okay. And who was second? Thank you. Dan Coffer?
Aye.
Clifford Warren?
Aye.
Albert Szymanski?
Aye.
Aaron Dennis?
Aye.
Ruth Harris?
Yes.
Keith McWilliams?
Aye.
Motion carries.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondent within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case.
Next case is, excuse me. The next two cases have been withdrawn. Those are 2617 Nordman and 206 Kirkland. So our case is going to be 406 South Pine Street. Officer John Parks presenting.
The address is 406 South Pine Street, case number CCB-0262-2025. This property is zoned R2, single-family residential. Violation cited was section 26-171, subsection A, permits required. On May the 2nd, 2025, while conducting a site visit at a neighboring property, I observed that fencing had been installed. A check of the permit system found no permit for the fencing. The property was found to be in violation of 26-171, subsection A. On May the 7th, 2025, a notice of violation was posted on the property with an initial compliance date of June the 30th, 2025. A copy was also mailed, certified mail, to the property owner and is being returned to the sender. On July 7th, 2025, a check of the permit system found an application with a resubmittal required status. On August the 8th, 2025, a check of the permit system found the application in a resubmittal status as well. It is staff's recommendation to the board to find Gary L. Tuthill, DEC Trust and/or entity in violation of 26-171A and give until September the 12th, 2025 to bring the property into full compliance. If the owner does not come into compliance, it is staff's recommendation to impose a fine of $50 per day until the property is brought into full compliance, maximum fine not to exceed $10,000.
And for the record, there is no one here to speak on this case also. Any questions from the board?
So the application for the permit is in,
Well, they've submitted an application. There's missing information or information that they need further information, so the building department has returned it saying that it's incomplete or they need additional information. It's a resubmittal required. That's the same thing as still not having a permit. No permit has been issued. It's been in that status. I checked it on July the 7th. It was in that status of resubmittal required, and I checked it again on August 8th, and it's still the same thing. There's no resubmittal required, meaning there's been no action taken by the property owner or the contractor to submit anything to the building department.
and any communication between?
I have no communication.
Any other questions? Can we get a motion?
I so move.
I second.
But we're giving them till September, right?
My recommendation is September the 12th, 2025. The board can do what the state wish.
Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Szymanski,
Aye.
Aaron Dennis,
Aye.
Ruth Harris,
Yes.
Keith McWilliams.
Aye.
Motion carries.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondent within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case, please.
Next case is case number 0308-2025. The address is 765 East 3rd Avenue, presented by Officer John Parks.
The address involved is 765 East 3rd Avenue, referred to also as Diamond Detailing is the business that's operating there. The code case is CCB-0308-2025. This property is zoned B5 Planned Shopping Center. Violation cited was 26-171 subsection A, permits required, and 74-146 local business tax imposed. On May the 21st, 2025, I observed signage for Diamond Detailing, a business operating at this location. A check of the BTR system found no BTR. Additionally, a check of the permit system found no permit issued for the signage. On May the 30th, 2025, a notice of violation was posted on the property with an initial compliance date of June the 30th, 2025. A copy was also mailed, certified mail, to the property owner and the business, and was signed for and accepted by both the business and the property owner on June the 2nd, 2025. On August 8th, 2025, a check of the permit system found an application for a sign permit has been submitted, but it is in a resubmittal required status since June 25th, 2025. A check of the BTR system found an application with no action taken. Excuse me. I have been in contact with a representative of the property owner in reference to this property. There's, just for information, there's a second case that you'll hear in just a few minutes that is also at the property that's very similar, but they are two separate cases. The manager at this location, the property manager at this location, has advised me that the businesses are no longer located there. I have been by, I have not seen that the businesses are operating there at this time. However, they have been operating and there was no BTR issued, and obviously the permit for the sign was in a resubmittal status. Therefore, it is staff's recommendation the board define Freitag Mark J. Trust, Mark J. Freitag Trust of 1998, and/or entity in violation of 26-171 and 74-146, and give until September 12th, 2025 to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to impose a fine of $100 per day for violation of 26-171 until the property is brought into full compliance. Maximum fine not to exceed $25,000. Additionally, if the owner does not come into compliance for Section 74-146, it's staff's recommendation per Florida statute 205.053, a one-time fine of $250 be imposed for operating without a BTR.
And for the record, there is no one here to speak on this case. Any questions from the board? Do we have a motion?
I so move.
Second.
Okay.
Dan Coffer,
Aye.
Aaron Dennis,
Aye.
Clifford Warren,
Aye.
Al Szymanski,
Aye.
Ruth Harris,
Yes.
Keith McWilliams.
Aye.
Motion carries.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case, please.
Next case is 0308-2025, address 765 East 3rd Avenue. I'm sorry, I read the wrong case number. 0373-2025. 765 East 3rd Avenue. Officer John Parks presenting.
The address is 765 East 3rd Avenue, also we'll refer to as Drake's for the business operation. The case number is CCB-0373-2025. This property is owned B5 Planned Shopping Center. The violation cited is section 74-146, local business tax imposed. On June the 27th, 2025, I observed signage for rentals of bikes, kayaks, paddle boards, and surfboards. An internet search for a rental business at this location found Drake Hickman, Drake Surfing Lessons and Rentals doing business at this location. A check of the BTR system found no BTR. On July the 29th, 2025, a notice of violation was posted on the property with an initial compliance date of August the 18th, 2025. A copy was also mailed certified mail to the property owner and the business and was signed for and accepted by both on August the 8th, 2025. On August the 18th, 2025, a check of the BTR system found no application on file. I have been in contact, as I said previously to the other case, same thing again, with the manager, the property manager for the property. He has advised me that there has been some falling out with the tenant being Drake's, as well as the other one as well, but this is separate. But in reference to Drake's, he did send me an email, a letter by email that he's giving to the board, and I will present it to the board and let you read it for yourself. I advised him I could not advocate for him on his behalf, but I could present a letter to the board in reference to this case. Please note that this letter is not signed, and it also is not in the name of the property owner. It's literally someone who is representing them as the manager of the property, basically. My intentions, again, I went by today, and I observed no business activity for the Drakes or the previous one case that we just talked about in operation today, but knowing that my recommendation was going to be for finding a non-compliance, but also giving it a new compliance date of September 12th, I believe that that gives enough time to verify that the businesses have, in fact, vacated and are not doing business. Give us a little leeway on that. That's the reason for my recommendation. That being the case, it's staff's recommendation. The board find Freitech M.J. Trust, Mark J. Freitech Trust of 1988, and/or entity in violation of 74-146, and give until September the 12th, 2025, to bring the property into full compliance. If the owner does not come into compliance for section 74-146, it's staff's recommendation per Florida statute 205.053, a one-time fine of $250 be imposed for operating without a BTR.
Okay. And for the record, there is no one here to speak on this case. Do we have any questions from the board?
Haven't seen the letter yet.
So he's no longer operating?
That is
a
what
business
my
in this?
understanding is. I have not confirmed fully. Like I said, I went by today just as a cursory view based upon the letter that I received and the communications I had with the manager of the property as a good faith, but also noticing the dates involved and how this has proceeded. I felt that it was it would be prudent to continue on as we had already planned, have a order that would allow us to come back with already an imposed fine or a repeat situation in the event that this is some type of a temporary measure versus a permanent measure.
Any other questions from the board? Do we have a motion?
I make a motion to accept the officer's recommendation.
And a second?
Second it.
Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Szymanski,
Aye.
Aaron Dennis,
Aye.
Ruth Harris,
Yes.
Keith McWilliams.
Aye.
Motion carries.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case, please.
Next case is 690 East 3rd Avenue, case number 0661-2024. Officer John Parks presenting.
The address is 690 East 3rd Avenue. Code case is actually CCSM-0661-2024. This property is zoned B2 neighborhood business. Violation cited was 26-171, permits required, section 74-146, local business tax imposed. This was initially a special magistrate case, but due to conflicts, the case had been moved from special magistrate venue to the code board venue because of conflict. So that's the reason for that, and that's the reason why it's being brought to here for the first time. On August the 30th, 2024, Code Compliance received a complaint regarding pavers, fencing, and seating being installed behind the business without a permit. On September the 3rd, 2024, and recognize these are 2024s, I observed the improvements had been made to the property that expanded seating for the business as well as items installed without a permit as advised. A check of the BTR system found no updates to the BTR for seating of the business at the location. A check of the permit system found no permits for the improvements. The property was found to be in violation of section 26-171 and 74-146. On October the 3rd, 2024, a notice of violation was posted on the property with an initial compliance date of October the 25th, 2024. A copy was also certified mailed to the property owner and was signed for and accepted on October the 7th, 2024. On July 29th, 2025, a notice of hearing was posted on the property and a copy was also certified mailed to the property owner and was returned to sender. On August the 5th, 2025, the owner met with the building department personnel and was advised that he still needed to obtain some permits in addition to what he had already applied for. An updated BTR was applied for and issued. There has been a lot of communication with this property owner over the last year, as well as his attorney, to even include just a couple of days ago. We have reiterated throughout the standings of the city, of the requirements, and the need for following the codes as stated. We have given a lot of latitude recognizing some of the complexities of this as well. But now that we are running at an entire year later, and also because the fact that we did have to change venue from the special magistrate to the code board, it is one of those things that we're making this recommendation as we are now. It is staff's recommendation that the code board define Beachside Tavern LLC and/or entity in violation of 26-171 and give until September 12, 2025 to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to impose a fine of $100 per day for violation of 26-171 until the property is brought into full compliance. Maximum fine not to exceed $25,000.
And for the record, there is no one here to speak. Oh, there is? Sir, I'll have to have you sworn in. That's why we did that in the beginning. Did you get sworn in?
Okay. Okay, here's his attorney. I didn't.
Oh, I am sorry.
Okay, so in that case,
Okay.
In the matter to which you are about to give testimony, do you swear to tell, or swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
You have been sworn in. Thank you.
how you doing, sir? I'm sorry I didn't recognize you.
No, it's
prior
okay.
to-
I got in a little late.
It's all right, that's fine.
And just for the record, if you could speak into the microphone and state your name.
Yes, sir. My name is Corey Brown with Storch Law Firm, 420 South Nova Road, Daytona Beach. The officer here has been speaking with my colleague Joey Posey. He couldn't be here, so I came. This is really going to be pretty simple and brief here. My understanding is that the property owner has made application for what they need to apply for here, and that the improvements and whatnot are actually done right now. So I think that provided that the city can work through this process and issue the approvals, permits, whatnot, for this property within 30 days, which is when we're coming back or when the fines would begin. Provided that, I think that we can make this work and get everything squared away. So that's really all there is to it as far as I'm concerned. So I'm available for any questions or if anybody has anything. So.
Yeah, when did you start making the permits? When did you make application for the first permit?
I think that the applications, so again, I'm standing in for another attorney. I think the applications were made very recently.
I support that. It has been, there's been some permits that, there have been some permits that were obtained, but not all permits. So again, we do halfway measures sometimes, thinking that it's the full measure, and it may not be, not necessarily calling anybody's efforts out, but there was efforts made. That's the reason why this case has been going on for a year, because when we see progress, we like to extend to, as our goal is compliance. However, we then find that at a certain point, we do have to bring it to the board or the magistrate. The most recent applications have just been made within this last week. So does that answer your question?
Can you explain, as you were reporting the case, what caused the gap between October 24th and July of 25?
I'm
Can
just
you explain
going
that gap? I
The
couldn't.
best way I can explain it is several factors. We had this was all slated and originated for the special magistrate. We had the previous special magistrate ended her time in November. We had a hiring process where we were going and getting a new magistrate. The new magistrate came in. It wasn't noticed until the magistrate received the agenda that she had a conflict, and therefore that's the reason why it had to be moved from, I believe it was originally slated for, I want to say July, but I might be mistaken. I'd have to verify that. But probably most likely July was the time. It could have been actually May, one of those hearing dates, but then that at the hearing date is actually the time that we found out that there was a conflict. So it had to move venue to the code board, and that's the reason why you're getting it now versus that. So there is some measures that were not the property owner's necessarily situation, but at the same point, the property owner has been made aware of the violations a year ago. That's where our issue is.
Okay, thank you.
Kathy, go ahead. Explains it.
All right, you're saying the work was done a year ago. But
Everything is
applications were
after that.
just recently.
Yes, all the work has actually been done over a time frame of actually a couple of years. If you notice the aerial shots that were just up, you can see that, and I'm trying to recall the year when it comes back around, but the top one is a couple of years back, and then the next one is different year, and let's just say that they're back-to-back years, so I'm not sure exactly. But this is
But no permits.
without the permits. And I will say that the owner had advised me that initially he believed that either no permits were required or that he was of the understanding that permits were being handled by contractors or such. I know that there's been, pardon me for the word excuses, but there are being excuses given and made, and that's the reason why the city has been lenient in bringing it to a board or the magistrate, because we have recognized that there's certain issues, but again, we have found that it's time to bring this to an enforcement action.
Could you, I'm sorry, go ahead. No. Could you reiterate what your recommendations were again?
Our recommendations, let me reread it so that way it's correct. That we would find that the staff recommendation is that the board find Beachside Tavern LLC and/or entity in violation of Section 26-171 and give until September the 12th, 2025, to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to impose a fine of $100 per day for violation of Section 26-171 until the property is brought into full compliance. Maximum fine not to exceed $25,000. Obviously, the board has the power and authority to decide whatever compliance date they would want and whatever fine amount that they want and when the fine would start by their order type thing. So we're not in an objection to whatever the attorney is asking for as long as it's reasonable, but this is what our standing recommendation is.
Okay.
So
And-
if that helps you.
Yeah, and one other question. You said that these renovations were done like several years ago. And
Some of them have been done.
I guess,
We'll be talking about this again briefly in the very next case because the property owner for this property owns the neighboring property and has done things jointly, believing that both properties belonging to him, he financial or for whatever purpose had it done at the same time. So therefore, to sit here and timeline each improvement and when exactly each improvement occurred, I can't give you that. I'm sorry, I don't have that.
I guess the question I was asking, and maybe Grant, you would know better on this. Is there almost like a time limit on how long you can go back for someone for finding them that they didn't have a permit for something? If you're going back several years on a property, because I'm not sure of that.
No, I mean, certainly the owner has been given notice and they've been dialoguing with the city, so he's been on notice of those violations, so there wouldn't be any concerns with reaching back too far.
Okay.
And just, I think if the attorney's here and is willing to say they're working on those applications, then it's up to the board in terms of whether or not they want to accept staff's recommendation or perhaps set another date, but that's your determination.
Okay, thank you.
I can say when I took the aerial photo pictometries and for his comparison, if I recall, and I can't make out the exact dates at this point.
For the record, the top photo is January of 23 and the bottom photo is January of 25.
Okay, thank you. So there's only a 2-year gap between those. I was going to say, I know that I would not have reached back prior to probably 2020 as an example, a 5-year or so. You know, again, I realize and recognize what you would be saying on something like that.
John, just
Yes, sir.
one other thing is, usually when a permit is offered, I don't know if you
I'm
want to
sorry,
call
what's
this.
that, sir?
I don't know if you want to call this an alteration or a renovation or what, or 2 years. I know that anytime you take a permit, you usually have to submit some type of plans, approved plans and stuff. Have approved plans been made before this happened? Every contractor in the state of Florida knows they need to take out permits. So that's on their
I
license.
can't speak for the intention of the property
Okay.
owner or his contractors. I can say that in discussions, it's come up on several different items that either The answer for this has been either we didn't realize that a permit was required, or we thought that was being taken care of. It's only been within the last, I'm going to say, probably month and a half, that truly there seems to be a full understanding, even after a couple of discussions with the attorney representing, not this attorney, but the other attorney representing. And the attorney had some very good questions, and I researched information for him, and he understood where the city's viewpoint was on this for code enforcement. And I, without speaking on his behalf, I can't, but I can say I've got a firm feeling that I believe we're all on the right track now. It's just ensuring that the permits get issued, so that way we can ensure that things do meet code for safety standards, that type of situation. Immensely, obviously safety is always prominent. So that's the reason why we are seeking to get an order that kind of forces the issue, makes things follow up. Again, we wouldn't be objecting to anything that the board decides as far as more time or whatever either. It's just, this is just a standard recommendation. Sure. If they're asking for more time, we're not interfering. It's just, we recognize it should be reasonable is what we're asking for. Yes, ma'am.
2 questions. You said the other property, which I guess we're going to do
We'll
this
be talking
after a
about
few.
that. Yes, ma'am.
Where's permits taken for that being done?
The other, I don't want to jumble the cases
Okay.
because there are separate cases. And I'll say this, this is a restaurant, cafe, bar type of business, and the other one is an apartment type of business, so we're not talking the same type of business, so it wouldn't be fair to judge it as the same.
And one more question on that, just for my
Mm-hmm.
knowledge. Why does it go to the magistrate?
We've had, before in the cases where we had more complex legal standing cases, we usually put those towards a magistrate because the fact that there is a legal requirement for a magistrate not to judge your board as any type of incompetency, but it's just easier sometimes for someone who's dealing with legal law and code already to understand and determine that. Again, it doesn't matter. We're just looking for an order. It doesn't have to be a magistrate order. It could be a code order. And there's no reason that it has to go to a magistrate. It just was originally set for.
Thank you.
Yep.
I'll expand on that
Yeah.
a little bit. So basically what we're trying to do is to split the cases between the special magistrate and the code board. So what we've determined is that we will take the commercial properties to the special magistrate and residential properties to the code board.
Perfect. Thank you.
Okay. Do we
I've got a
have,
question for the attorney.
Yes, sir.
What items have been brought into compliance or permitted, and what is still outstanding? And you know, what would it take for them to bring the entire property into compliance at this point?
So my understanding is that we have applications for approval of permits on everything, and that the improvements that are going to be done are there. So really what we're looking for is enough time to get the city to sign off, to inspect, to look, to make sure it's correct, and to sign off on that, you know, before we start getting fines. I think that you understand, I'm sorry, what's your name again?
John, that's fine.
Officer John. I think John, Officer John here understands a little better about the progress or the status of the different improvements.
I do.
Thank you.
On that, and in the next case, I'm going to actually go into that a little bit more. There is an application for, we'll call it the missing permits, for a better term. The missing permits, there's an application for that case in that parcel. There was somehow a miscommunication or misunderstanding somewhere where there was a belief that the application would encompass and take care of both parcels, which unfortunately, even though the owner owns both parcels, each parcel requires its own permit because unless they are joined into one parcel, There could be a selling at a later date, and there would be an issue for, was this permit, was this not permitted? And those would become questions as well. There's also different standards between an active grill restaurant and an apartment complex as far as standards as well. You could have the same type of situation going on there, but there might be two different standards based upon the code, the zoning, that type of thing. So that's the reason why there is a requirement. Unfortunately, at this time, there is no application for the missing permits for this exact property for this violation. Therefore, that's where we are at on this one. Again, we'll go into the other one in a minute, but if that helps you understand, then they answer your question, hopefully.
Okay, just to clarify something, for the commercial property I'm talking about now,
Yes,
the
sir.
one that's been over there, okay? Is all the permits for the past work and the present work being accessed, or
There
in other words,
is-
what has been done previously to everything?
There is
Are they gonna-
there is no construction going on at this property at this time. Everything is an after-fact permit for this property, everything that they would need to apply for.
So in other words, what happens is, once they get it, you're gonna do the work that has been done previously, and that's gonna be inspected as well? That's,
In hopes and theories, the notice of violation, I'd like to bring your attention to the notice of violation because it is important on that to understand what we're asking for. And let me. All right. Yeah. Okay. The notice of violation, talking about just the permits under 171 that was issued back on August the 30th, 2024. Is that correct? You see it?
That looks correct.
Okay, all right. And I'm just quoting from our notice of violation. Obtain required permits for pavers, patio, fencing, awnings, and temporary toilets and restroom trailer. There was a restroom trailer on the property that's been removed. There has been some other things that they have applied for without having my computer and having the exact permits available or someone from the building department to tell me what exactly has been applied for. I'm not exactly sure, but I do know that they have applied for pavers in the past, but whether that paver application actually encompassed everything or just encompassed, as an example, 40 square feet. I can't make any testimony on that. I can just tell you that it is incomplete. There's still things that are missing from a permit process, and that's where we stand on that.
thank you.
So a question for the attorney.
Yes, sir.
Do you guys feel September 12th is enough time to have that all completed by? I guess is my question for you.
So I was sort of, and you have to forgive me, my impression was that we're going to have roughly 30 days to try to get the permits approved.
The difference being, we're in the month of August, it would be the month of September. That's probably where, and also the fact is the next board meeting would be approximately 30 days, type thing,
Okay.
which we would be coming back for. And again, the board has the authority to change and modify and come out with whatever decision they want. As an example, if you wanted to review this in 30 days as the next one, you could do that. If you wanted to give more time, if you thought that, from your experience that more time was needed, then that's fine too. But that's completely up to the board on time. We only recommend, we don't mandate in any way, shape, or form.
Yeah, so I recognize this has been going on, quite frankly, way too long. At this point, I want to make sure that I think the property owner is very serious, hasn't made the application for the permits that need to be done, and wants to go ahead and get everything approved and done and correct. So we just need enough time because it's not something where it'll happen tomorrow. You just need enough time to actually get that done before, Fry and start crewing. We have to say, wait a minute, we've got an application in and they're coming out and inspect tomorrow, but et cetera. So you know, at some point here, you know, the property owner has to do what they have to do. They've got the applications in. I think everything is done that needs to be done for the city to review everything, all the improvements, and say, yes, here's your after-fact application. You know, so I'm just asking for enough time to be able to get that process done. And once it's done, we should all be good. You know, I was speaking with Mr. Posey, the attorney, I was under the impression we were getting about roughly 30 days to go ahead and get that process done. And I think that's probably the amount of time it's going to take the city, you know, hopefully faster, but that's what I would expect roughly about time it would take. And, you know, once the property owner has, despite all this time that's gone by, once the property owner makes the application to get it done, we have to work that into the city's schedule to get someone to come out and review it and get the paperwork done. It's that simple.
Any more questions? Can we get a motion?
Yeah, I'd like to make a motion to accept John's recommendation for the given amount of time. I think it was September 20th.
My recommendation was September 12th, if I
12th.
recall. And just on that, as a standard practice, not necessarily that it's law or anything, we don't usually ask in this first hearing for the fine to be imposed immediately, levied, any type of thing like that at this time. So we're not talking about, we're asking for the fine to be imposed today type of thing. We would be coming back next month, September, to the board anyway, presenting this and asking at that point in time. So in the event that you do take that recommendation that I've made on the 12th, whatever, it just gives you another time frame to literally review. You can then change from there if you needed to. It's not hard and fast.
The reason I recommend that is this case has to go on. So let's get something down, we'll get down there, and then if something happens at the next time, we'll come back and we'll discuss
completely
it,
to the board.
and we'll have a little bit of a foundation for us to work on.
That's completely to the board's decision.
That's why I
Is that a
make
motion?
that recommendation.
So that is a motion. Do we have a second?
Second.
Sorry, just for the record, could we repeat the motion?
The September 12th.
Accept staff's recommendation of
Yes, the
September
staff
12th. to come-
recommendation, yes.
Thank you.
Thank you.
Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Szymanski,
Aye.
Aaron Dennis,
Aye.
Ruth Harris,
Yes.
Keith McWilliams.
Aye.
Motion carries.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case, please.
Next case is 715 East 2nd Avenue, Unit 3. Officer John Parks presenting.
The address is 715 East 2nd Avenue. Excuse me. The case number is CCSM-0662-2024. This property is zoned B2 Neighborhood Business. Violation cited was 26-171, permits required, Section 74-146, local business tax imposed. On August the 30th, 2024, Code Compliance received a complaint regarding pavers, fencing, stairs, decking without a permit. On September the 3rd, 2024, I observed that the improvements had been made to the property as reported without a permit as advised. A check of the BTR system found no BTR for the apartment complex to be rental property. A check of the permit system found no permits for the improvements. The property was found to be in violation of Section 26-171 and 74-146. On October the 3rd, 2024, a notice of violation was posted on the property with initial compliance date of October the 25th, 2024. A copy was also mailed, certified mail, to the property owner and was returned to sender. On July the 29th, 2025, a notice of hearing was posted on the property and a copy was also mailed, certified mail, to the property owner and was returned to the sender. On August the 5th, 2025, the owner met with the building department personnel and was advised that he still needed to obtain some permits in addition to what he had already applied for. There is still no BTR application for the apartment rentals. As we had said in the previous case, because it does refer to conversations that involve this case, there's been communication with the property owner, with the attorney, with the building departments. There is a application on file right now that is no actions taken because it's just too new. It's not in review, anything that I'm aware of. It's just literally been submitted. But there has been an application submitted that would hopefully encompass the violations of 171, the permit required. There's still no application for a BTR to operate the apartments as rental property. It is staff's recommendation the magistrate to find Mark D. Dam and/or entity in violation of sections 26-171 and 74-146 and give until September the 12th, 2025 to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to impose a fine of $100 per day for violation of 26-171 until the property is brought into full compliance, and for section 74-146, there should be no fine, only a finding of noncompliance. Maximum fine not to exceed $25,000. My understanding and hope and belief is this. The previous case, they fixed their BTR. This case, the BTR is going to be hung up anyway based upon the fact of the permit applications and the permit issues. Our city will not issue the BTR with those complications already. So to say, well, you haven't applied for this, recognizing that they do need to apply for it, but they need to apply for it when it can reasonably be issued. To apply for something that you know you're not going to get issued, and I'm not advocating for them, I'm just saying it's not fair to them. So therefore, I don't believe a fine for the BTR, but a finding of noncompliance, because future, in the event that the BTR does not come about and it somehow slips somebody's mind conveniently or whatever the situation, it can then be utilized as a repeat offense because it is a violation that did need to already be, that was addressed, but wasn't fully addressed. So that's the reason for my recommendation.
Would you like to speak on?
Yes, sir. Corey Brown with Storch Law Firm, 428 South Nova Road, Daytona Beach. Yeah, I imagine that with that BTR application, if it hasn't been submitted, I imagine the reason is because they're waiting on the permit part. But the intent is to get all this stuff done before the date that within the 30 days I spoke about. And the intent is to have everything in, get it all reviewed, get it approved, and as quickly as possible, get the BTR, be done with this. So that's just asking for the time to do that. And I can't thank the city enough for just all the cooperation they've given of this for a while now, and working with to try to get this site, which is a complicated site, under control and all permitted and legal. So thank you for your time.
Okay, thank you. Any questions from the board? Can I get a motion?
I move to accept the recommendation.
Second.
Who was second?
Go ahead.
Okay, give me 1 moment. Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Szymanski,
Aye.
Aaron Dennis,
Aye.
Ruth Harris,
No.
Keith McWilliams.
Aye.
It is 5 to 1, motion carries.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Okay. As we have no more cases, is any discussion among the board members?
Thank you, John.
Then I'll adjourn the meeting. Thank you.
Is that it for discussion?